Citizens United was decided in 2010, but the story behind that case begins more than a century earlier. Just after the Civil War ended, a New York congressman by the name of Roscoe Conkling was part of an effort to add a 14th Amendment to the Constitution. The goal of this provision was to secure what Lincoln called the new birth of freedom for blacks who had been enslaved in the South. The amendment stated, among other things, "Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws." Now, Roscoe Conkling was a member of the congressional committee that drafted the 14th Amendment. Some years later, he retired and became one of the most successful lawyers of his day, representing robber barons and the great railroads like the Southern Pacific. In 1882, he was nominated to the United States Supreme Court. He was confirmed by the Senate, but declined to serve. He was the last person ever to turn down a Supreme Court appointment after he had been confirmed by the Senate. Conkling didn't want to be a Supreme Court justice. He was simply making too much money as a lawyer for the railroads. Now, railroads were the richest and most feared corporations in America. When state lawmakers tried to regulate the railroads to serve the public interest, the railroads hired lawyers like Roscoe Conkling to fight back. In California, for example, San Mateo County imposed a special tax on railroads like the Southern Pacific, and Conkling went to court to argue that the tax was unconstitutional under the 14th Amendment because it treated corporations differently than it treated individuals who weren't subject to the same tax calculation. Now, there was just one little problem. The 14th Amendment to the Constitution did not appear to grant corporations like the Southern Pacific Railroad any rights whatsoever. It guaranteed the rights of persons. But understand this about Roscoe Conkling: he was not the type of lawyer that would let a little thing like the text of the Constitution get in his way. And he argued in the San Mateo case that the drafters of the 14th Amendment had intended to protect the rights of corporations as well. And who would know better than Roscoe Conkling, who had served on the committee himself? In court, Conkling explained that the drafters of the 14th Amendment had rejected using the word citizen in the Due Process and Equal Protection Clause and used the word person instead, specifically to protect business corporations. Now, indeed, the law had previously recognized corporations as legal persons for certain limited purposes. In 1819, in a case involving an effort by the state of New Hampshire to take over Dartmouth College, Chief Justice John Marshall recognized the legal status of corporations. A corporation, he said, is an artificial being, invisible, intangible, and existing only in contemplation of law. Nevertheless, Marshall wrote, quote, "Being the mere creature of law, it possesses only those properties which the charter of its creation confers upon it, either expressly or as incidental to its very existence. One of those properties," Marshall further explained, was, quote, "individuality, the ability of those who make up the corporation to act as a single individual. Because a corporation was an individual, it could own property, and it could form contracts like the charter that existed between Dartmouth College, a corporation, and the state of New Hampshire. Under the Constitution's Contract Clause, which bars any law that impairs the obligation of contracts, New Hampshire was obligated to respect Dartmouth College, the charter of Dartmouth College. As Marshall wrote, "It is chiefly for the purpose of clothing bodies of men with these qualities and capacities, like the right to own property or to form contracts, that corporations were invented and are in use." Now, Roscoe Conkling told the justices that because corporations were legal persons, they were protected by the 14th Amendment just like any other person. Now, there were some problems with this interpretation. Now, first of all, no one in the public debate over the 14th Amendment had ever mentioned business corporations, so this was a surprise in that way. Second, the 14th Amendment uses the word person or persons outside of the equal protection and due process clauses in ways that clearly don't apply to corporations. Section 2 of the amendment, for instance, provides that the number of seats a state has in Congress is determined by counting the whole number of persons in each state, excluding Indians not taxed. And no one has ever suggested that corporations should be counted for purposes of apportionment. Indeed, if corporations were really persons for purposes of the 14th Amendment, Delaware, where the plurality of corporations are incorporated today, would currently be entitled to something like 53 seats in the House. So Conkling was asking the court to interpret and construe the word person used in two consecutive sentences in the Constitution, both added to the Constitution at the exact same time, to mean two totally different things. But Conkling had an answer for this problem. He said he was in possession of an unpublished journal of the drafting committee in Congress, their deliberations. His journal, Conkling said, showed the true intent of Congress. The argument of Roscoe Conkling, whose statue stands today in New York's Madison Square Park, has been termed the conspiracy theory of the 14th Amendment, that under the guise of protecting the freedmen, lawmakers such as Conkling snuck into the Constitution broad protections for business. Now, it turns out that the Supreme Court never issued a final ruling in Conkling's case. The case was settled by the parties, and the case was ultimately declared moot. But just a few years after that, the exact same issue was presented to the Supreme Court in a case called Santa Clara County against Southern Pacific Railroad. The parties had argued in their briefs that corporations were persons for purposes of the 14th Amendment, and citing Conkling's argument in the San Mateo case. But at the very beginning of oral argument in that case, the Chief Justice, Morrison Waite, announced that the court did not want to hear argument on that issue. And indeed, the court decided this case in favor of the railroads without ever ruling on the railroads' constitutional rights. Yet the court reporter at the time, a man by the name of J.C. Bancroft Davis, on his own decided to add a headnote to the opinion of the Santa Clara case. The reporter is the person who's like a functionary who's responsible for publishing the court's opinions. The headnote purported to quote Chief Justice Waite as saying, "The court does not wish to hear argument on the question whether the provision in the 14th Amendment to the Constitution, which forbids the state to deny to any person within its jurisdiction the equal protection of the laws, applies to these corporations. We are all of the opinion that it does." Now, a headnote is not part of the court's opinion. It's something that the publisher or the reporter puts in there for lawyers who are conducting research for their convenience. It is usually a summary of what the court decided in the case, and it is not binding. Yet, ever since Davis put his footnote in the Santa Clara case, courts, including the Supreme Court, have cited Santa Clara for the proposition that corporations are protected by the Constitution. Bancroft Davis, the court reporter, it turns out, had previously served as president of the Newburgh and New York Railway Company. Now, Davis's headnote was misleading, but it nevertheless captured the mood of the Supreme Court. And over the next few decades, a conservative Supreme Court would aggressively use the 14th Amendment to protect big business and strike down burdensome state and federal regulation. Scores of laws were invalidated for restricting corporations' rights. Meanwhile, in cases like Plessy against Ferguson, the Supreme Court refused to read the 14th Amendment to provide really any significant protections for blacks, the real intended beneficiaries of the 14th Amendment, against discrimination. The court even memorably said, "There comes a point where a man must stand on his own." But apparently the corporations still needed the Supreme Court. Now, still, even in this era of business-friendly courts, corporations were not afforded all of the constitutional rights of ordinary people. For example, no one thought that corporations had the same right as ordinary individuals to try to influence elections. In 1907, at the urging of President Teddy Roosevelt, Congress passed the first campaign finance law, the Tillman Act, which prohibited corporations from contributing to candidates. In 1905, the Supreme Court ruled in a case called Hale against Henkel that McAndrews and Forbes, a corporation that controlled the importation of licorice, had no Fifth Amendment rights against self-incrimination. Yet the court in that same case held that McAndrews and Forbes, which was under indictment for violating the Sherman Antitrust Act, was entitled to Fourth Amendment rights to be free from unreasonable searches and seizures. Now, although the firm in that case argued that it was entitled to all constitutional rights because corporations were legal persons, the court didn't base its decision on that at all. Justice Henry Billings Brown, writing for the majority, pierced the corporate veil to examine how constitutional rights would impact the people within the corporation. Corporations did not have the right against self-incrimination, he said, because the company could not be forced to take the stand and testify against itself. Right? It was impossible. The corporation is just an abstraction. Rather, an officer of the corporation's agent, would have to take the stand, and he could only assert the right of self-incrimination to protect himself, not to protect some third party, even if the third party was the principal to his agency. With regard to the Fourth Amendment, the corporation, Justice Brown explained, was entitled to be free from unreasonable searches and seizures, not because it was a person, but because because doing so is necessary to protect the rights of those people who make up the firm. The corporation is, the court said, after all, but an association of individuals under an assumed name. In organizing itself as a collective body, that association waives no constitutional immunities. Now, these two different rulings on the constitutional rights of corporations are very hard to square. Nevertheless, Hale does suggest an alternative basis for understanding corporate constitutional rights to constitutional personhood. That is to say, corporations have sometimes been accorded constitutional rights because they are associations of real people, and those real people unquestionably have constitutional rights. Over the course of the 20th century, the Supreme Court would continue to expand the rights of corporations. In a series of cases decided around World War II, the Supreme Court held that media corporations were entitled to the freedom of speech and the freedom of press guaranteed by the First Amendment. In Grosjean versus American Press Company, decided in 1936, the Supreme Court unanimously held unconstitutional a tax on newspapers put into place by the notorious Louisiana governor, Huey Long. The court explained that, quote, a corporation is a person within the meaning of the relevant clauses of the Constitution. In other cases involving media corporations, like the landmark New York Times against Sullivan ruling, the Supreme Court simply ignored the fact that it was a corporation claiming constitutional rights. If the law unduly burdened what the court saw as the freedom of speech or freedom of press, the law was unconstitutional, regardless of the identity of the speaker. Indeed, we might call this the third basis upon which corporate constitutional rights have been recognized. Instead of basing corporate constitutional rights on corporate personhood, or even on the idea that corporations are associations of real people who are entitled to constitutional rights, the court has often expanded corporate constitutional rights without regard to the fact that it's a corporation at all. The court has basically said the identity of the claimant of the constitutional right is irrelevant. Surprisingly, perhaps, famed consumer advocate and corporate critic Ralph Nader played an influential role in this process. As part of his crusade to help consumers in the mid-1970s, Nader's Public Citizen challenged a Virginia law that prohibited the ability of pharmacies to advertise the price of prescription drugs. As a result of this law, consumers couldn't easily comparison shop and find the best prices. Nader filed suit arguing that this law infringed on the freedom of speech. But he had two problems. One, his plaintiffs were consumers, not pharmacists. The consumer's right to speak wasn't technically infringed by this law at all. They weren't trying to advertise, they were trying to read, not speak. And second, that the Supreme Court had previously said that commercial speech, speech about the sale of goods and services, was not protected by the First Amendment. So Nader and his legal team came up with an ingenious solution. They argued that by restricting the pharmacy's speech, the Virginia law really burdened the rights of consumers. Nader asked the court to strike down the advertising ban because it interfered with the rights of consumers, the listeners, the hearers, the audience for corporate speech, who were deprived of the ability to hear what the pharmacist had to say. Forget the identity of the speaker, Nader said. Virginia's law was an infringement of the listener's rights. And the Supreme Court agreed, and in Virginia State Board of Pharmacy against Virginia Citizens Consumer Council had held for the first time that commercial speech was protected by the First Amendment. And in order to make informed choices, the court explained, consumers had a right to the free flow of information regardless of its source. Now, Nader's logic would subsequently be used by the Supreme Court to expand the rights of corporations to influence elections. In 1978, 2 years after the Virginia pharmacy case, the Supreme Court held that business corporations had a constitutional right to speak about ballot measures in the Bellotti case mentioned earlier by Jessica. The court's decision in that case was written by Justice Lewis Powell, who explained that under the First Amendment, the identity of the speaker was irrelevant. It didn't matter that the law at issue only restricted corporations. The public had a right to hear what corporations, or anyone else for that matter, wanted to say. Nader's argument in Virginia Pharmacy provided an especially attractive way of going about this for Justice Powell, who just months before his nomination to the Supreme Court in 1971 wrote what was supposed to be a confidential memorandum to the United States Chamber of Commerce. You know, the 1960s and early 70s, you'll remember, ushered in a remarkable wave of laws protecting consumers and workers and the environment. Richard Nixon, that radical lefty, signed into law the Occupational Health and Safety Act and the Clean Water Act. He expanded the Clean Air Act. He oversaw the creation of the Environmental Protection Agency. Powell's memorandum called for corporations to fight back. No thoughtful person, Powell wrote, can question that the American economic system is under broad attack. Businessmen had to organize, to create staffs of social scientists to write and speak in defense of business interests, to take to the airwaves, to shape public attitudes, to become more politically involved. Today, Powell's memorandum is widely credited with inspiring the creation of right-leaning foundations like Coors and Olin and Scafee, and think tanks like the Heritage Foundation and the Cato Institute. These organizations would seek to expand the political influence of corporate America, a goal furthered, no doubt, by Justice Powell in the Bellotti case. So where does Citizens United fit into all this? Well, much of the criticism of that case is focused on corporate personhood. Yet I think that corporate personhood was not nearly as central to Justice Kennedy's opinion for that court as it is often assumed. Nowhere, for instance, does Justice Kennedy in that case say that corporations are persons. What Kennedy's opinion in Citizens United does do, however, is rely upon the other two ways in which the Supreme Court has expanded the constitutional rights of corporations. At several points in the opinion, Kennedy explains that the identity of the speaker is irrelevant, taking up Nader's argument. Because political speech benefits the public, corporations had a right to speak it. Quote, political speech is indispensable to decision-making in a democracy, and this is no less true, Kennedy wrote, because the speech comes from a corporation rather than an individual. At other points, Kennedy refers to corporations not as persons, but as associations. Quote, corporations and other associations, like individuals, contribute to the discussion, debate, and dissemination of information and ideas that the First Amendment seeks to foster. Yet under the campaign finance law at issue in that case, certain disfavored associations of citizens, those that have taken on the corporate form, are penalized for engaging in the same political speech. Is it possible that we could pass a constitutional amendment ending constitutional personhood and Citizens United would come out the exact same way? Now, Citizens United has outraged Americans. Some people believe that Citizens United will lead to a corporate takeover of American politics. I don't agree. As far as I can tell, corporations long ago took over American politics. Still others view the case as a prime example of the conservative judicial activism of the Roberts Court. Citizens United may indeed be that, but it didn't come out of nowhere. Citizens United is really, I wish to suggest, the culmination of a 200-year battle over the constitutional rights of corporations, one that the corporations have won time and time again. Thank you.